former central bank governor, Godwin Emefiele, has been granted bail by the High Court in Abuja after nearly 5 months in custody. The judge, Olukayode Adeniyi, denounced security agencies, saying that there must be an end to detention without trial. Arise correspondent Godfrey Emefiele has more.
It's been 151 long days in custody for the former bank chief, one of the most powerful men in the then President Muhammadu Buhari government. Emefiele here among family and friends outside the High Court of the Federal Capital Territory is finally getting to breathe the air of freedom after being locked away for so long. He had been in custody from the 10th of June following his suspension by President Bola Tinubu. But he's finally a free man for now. But in the courtroom, the trial judge, Olukayode Adeniyi, believes the rights of the former bank chief had been overly breached by being held in captivity for longer than necessary, and reinforced the order of November 2 for his unconditional release from custody. The judge admitted Emefiele to bail, ordering his team of lawyers, led by Matthew Bukar, to ensure he's produced in court on November 15 for his trial on alleged procurement fraud. And the second bail condition is for him to deposit with the court registrar his passport and other travel documents. This comes after the court had dismissed moves by the EFCC and Office of the Attorney General to frustrate Emefiele's moves for bail.
We thank the agencies of government, the DSS, the EFCC and the Ministry of Justice and the federal government generally for complying with the order of court that was made on the 2nd and reiterated on the 8th to produce the Mr. Emefiele in court. Now he was produced in court, and if you recall, part of the order was that he was to be produced for the purpose of being admitted to bail. The court has admitted him to bail, and the terms have been perfected, and he's free to go home and return for arraignment any day. The court will take his arraignment, tentatively now 15th of November.
Exactly a week from this Wednesday, Emefiele will be facing yet another legal hurdle at the same court before another trial judge. Godfrey Emefiele, Arise News.
Okay, so joining us now is Dr. Monday Oyekachi Ubani, former chairman, MBA section on Public Interest Law and Development, MBA Spilo. Great to have you, sir. I'd like to ask you, can you just, give us a recap of how we got here in the first place?
Thank you, Sunny. Thank you, Prof. Ruben Abati. I want to say this. I think it is when this government came in that Emefiele was arrested, first by DSS, and then he was kept in a very long detention, and then after so much cry, he was eventually charged, and when charged, his lawyers applied for his bail. He was granted bail, and the court ordered that he should be put in correctional service center pending the perfection of his bail. But unfortunately, DSS waited behind and then ensured that he was rearrested and taken into custody. And that again made a lot of people to begin to question the intention or the motive for detention. If you have detained him for such a long time and you eventually brought him before the court and then you charged him, and the offense for which you charged was bailable, and the court ordered that he should be granted bail, even ordered where he should be allowed to stay pending the perfection of his bail condition. You now rearrested him because, according to you, have not finished investigation. It left a sore note in our tongue. So we felt that wasn't right. So after how many months of detention by DSS, eventually they handed him over to EFCC, who have now taken over the prosecution of the former central bank governor. I think the court ordered that, look, you have detained him enough. If you cannot in any way charge him to court, release him unconditionally or bring him to the court so that we can talk about his bail condition. And EFCC eventually complied with that particular order, and that was 2 or 3 days ago. He was brought before the court, and his lawyers moved the application for his bail under Section 35 of the 1999 Constitution. I understand that the Office of the Attorney General opposed the bail, and then the EFCC lawyers said, look, it is a discretionary thing that the court can exercise. If they want to grant, fine. They are not opposed to him being granted bail. And I think eventually the court granted bail by handing him over to his lawyers. And then the lawyers were instructed to ensure that he is produced on 15th of November to face his trial. I think that this has been the summary of what has transpired so far. Maybe your next question probably would now elicit my own feelings and response to what has happened so far.
Well, I was going to ask you, Justice Adeniyi based his position, his ruling, on the fact that there must be an end to detention without trial. Mr. Emefiele was kept in custody for 151 days. There have been so many other cases like that, of persons who will just be arrested and they will be there for a very long time. The state will say they are investigating. Now, why do you think that these state agencies continue to act in this manner, knowing quite well that it's not proper to go against the principles stated in Section 35 of the 1999 Constitution, which Justice Adeniyi also reminded everyone in court of?
Thank you, Professor Ruben. I think we have a lot of work on our hands to do with our security agencies for them to really understand the objective behind criminal prosecution and prevention. The idea is that an accused person at every point in time is presumed to be innocent until the contrary is proved. Now, there is a philosophy in criminal jurisprudence, and that philosophy is that it is better for 9 persons who is criminally liable to go scot-free than for one innocent person to be wrongly convicted. Now, behind that principle is what happens in everything about criminal prosecution, trial, and sentencing. If you don't understand it, you will run into a problem. So our security agencies need to understand this fundamental fact, that at every point in time, before you rein in an accused person who is alleged to have committed an offense, you must have done 80% of your work in terms of gathering sufficient evidence that can link him to the elements of crime as provided for in the law, in the code. If you don't do that, you now rein in an individual and begin to now fish for evidence. That has always been the reason why we have these long detentions without arraignment, without trial. And that is a clear violation of the Constitution. Section 35, as you have rightly pointed out, guarantees the liberty of every person, including the man who is investigating, the security agent, who may leave service tomorrow and become a victim. So it's important we understand it and then give it, let it be in their mind that at any point in time, you are going to arrest somebody. Let it be that you have done sufficient work with regards to the establishment of the offense before you rein him in. If you don't do that, it is wrong for you to have done, get him in, put him in custody, which at the end of the day, if he has not committed any offense, how do you remedy the damage that you have done to that individual? So we want to really make our security agency in Nigeria to understand that the best international practice is get the person investigated, get sufficient evidence to establish offense. Then before you can now ask him to come in, the next thing is to confront him with all the evidence you have gathered. And if he answers to the court and you feel that he has committed offense, the next thing is charging to court. And that's why the court, the word used in the Constitution, Section 35, is reasonable time. 24 hours if there is a court within 40 radius. If there is none, 2 days. That is a reasonable time they call. If you don't do that, you are violating the person's right, putting somebody in detention for 151 days, and you have not preferred any charge against that individual. It's clearly a violation. I don't even know how you're going to remedy it. I'm not making an excuse for Emefiele. We all know what Emefiele did to this nation. We also know what he did in terms of not even obeying court order. But that cannot in any way account for some of us who are human rights lawyers now to support any violation of the right of Emefiele. That is my position. We must understand that. And that teaching must go on, using the television and radio to really educate our security agencies on the issue of presumption of innocence of every accused person, including them, because they can be a victim tomorrow. So if you understand that, then it is important that you give that right that is due to that individual in the course of investigation and prosecution.
But you said that teaching should go on in a society where it's become a norm. Okay, we're talking about Emefiele today. At least he's been charged to court. How about Bawa? How about Bawa that till date, we don't know what happened? Go ahead, sir.
I also think that the government owe an explanation as to what happened with Bawa, as regards to Bawa. Bawa himself was kept in a very long detention without any charge whatsoever. I think his lawyers went to court eventually to enforce his fundamental human rights. So what we heard next is that he has been released. And we don't know the condition of that release, whether he's going to be charged later and all that. So that again is a violation of the right of that young man. So I think that this government of President Tinubu, with an Attorney General that is very versatile and conversant with the laws, will be able to ensure that they keep to one of the agenda, which is respect to rule of law and respect to fundamental human rights. So at any point in time somebody is arrested, we're not asking that an accused person should not be prosecuted. We're not saying so. We're not encouraging criminality in the land, because any land where there is crime and you don't tackle it, with state instrument, then that means that you are creating crisis in the country. We are believing that the government will do the right thing in getting those who are criminals to be prosecuted and sent to correctional centers. Those whose behavior cannot fit into society. The nature of criminal jurisprudence that you take them to a place of retraining, of getting them back in terms of character so that they can join sane members of the society. That is why they call it now correctional center. It's no longer prison, because they must change their attitude in order to become part of the members of sane society. So in understanding that, we must make sure that those who are criminally minded in the country are kept where they will be retrained in order to join sane members of the society. But you must do it also within the bounds of law. There are provisions of the law. There are safeguards that the law has provided for those who are accused of a crime. You must give them fair hearing. You must not detain them indefinitely. You must give them an opportunity for them to have a lawyer to defend them. You don't assume that they're already guilty when the law has not said so. You can't keep them in detention when the law has not convicted them. That is absolutely wrong. It's a clear violation. You must make sure that they face and be heard. The law gives them opportunity to be heard before you now say, okay, this is a judgment of the court. Based upon preponderance of evidence, they can be convicted and kept where they can be retrained in order to join sane members of the society. That is the idea behind criminal prosecution and prevention. That is what I understand it to be.
Well, but all the state agencies that detain people indefinitely, they all have legal departments. To what extent are lawyers complicit in some of these violations that we have seen?
I agree with you. Most times we have leaders of these agencies that do not take instructions from their lawyers. Take, for instance, my own personal experience, with EFCC. Despite all the effort that the lawyers did in order to advise Magu at that time, look, if you say this man has committed an offense, there are already judicial decisions that says he has not committed any criminal offense. At worst, his matter is a civil matter. He said no, that he has lawyers who advise him from Lagos that he can get any charge, against me and all that. And he tried to do a manner, despite all the advice that was given by the legal department. So what I'm trying to say is that you can have lawyers who work probably as Attorney General and all that. It is another thing to have a leader that listens to the advice of lawyers. Most times, some lawyers, because of the fact that you don't have any job anywhere, and you don't want to lose your job, and you have understand the language of your master or your guy who is on top, who may not brook any disagreement or any opposition or any advice that is contrary to his own whim and caprices, and you don't want to probably be transferred to somewhere in Maiduguri or be kicked out of employment. Sometimes you are bound to listen, and bow down to the pressure of those who are in charge. But if you have a leader, if you have an organ that listens, that want to take a legal advice from those who are in the legal department, you have an issue that is cut out for you and made easier. But most times they don't want to listen. They have already made up their mind that this is what I want. It's either you give me the legal position that is in tandem with that, or I believe that you have compromised. So that is why most of the lawyers also have problems. But I also believe that some lawyers who are, very mischievous, who will not want to give the correct legal advice to their ogas.
Let's talk about this case even further. There was a time the judge at first gave him bail in Lagos, but we all saw the scuffle that ensued between the prison service and the DSS. I want you to talk me through that incident because it was a national show of shame.
Yes, it happened in the premises of the court, the hallowed court. We say that the court is very hallowed. It's a temple of justice that should not at any point in time be desecrated. The court was the place where you brought this man, you charged him because you want him to be heard, be given a fair hearing. Now, the court now said, look, I have listened to all the argument of counsels, and I feel that this man is entitled to bail because the offense for which you brought him is bailable. So, but this is where this man is going to remain until he perfects his bail condition. Any civil society, any sane society, any civilized society will listen and obey that particular court order because that is an arm of government that is very critical in resolving issues that has to do with law. And that is the judiciary. You must listen to the judiciary. You must obey the judicial decision. So if you have anything to the contrary, you appeal against it. So, but doing something that is contrary to the order of the court in the face of the court is clearly contemptuous and shouldn't be encouraged in any society because it gives a wrong impression that this must be a lawless country where anything goes, where order of the court can be disobeyed, even in the face of the court. That was actually what happened. It's something that is condemnable, and we are not going to clap. We're not going to clap for DSS, for doing that. And I think that the leaders also must really sometimes have become sensitive and say, look, there are certain things we are bound to do, and there are certain things we are not bound to do. Because people are watching, the world is watching. And we are living in 21st century, not 18th century. So with that understanding in mind, we must begin to insist on things being done rightly. I keep on saying this. We're not encouraging that criminals should go scot-free. We're not encouraging that people who have committed crime should be allowed to, no. We insist that they must be punished. We insist that they must, but there are safety guards that the law has provided. Those safeguards must be followed and complied with. That is what marks you out as a civilized country. There are things that any country can be looked at as a parameter that this country is really a civilized country. Is when you respect rule of law, you obey your court orders, you obey court judgment, and if you have any grounds against court judgment, you appeal against it. That is the way to go, and that is the way to grow the country and grow and give investors some level of confidence to come and invest in your country, believing that is a lawful country that obeys laws of the land. That is my take with regards to that.
Well, on that note, thank you, Ubani, for joining us. And I was amused. The promotion you gave me made me a television professor. Anyway,
You mean a professor.
Thank you very much.
You mean a professor, Doctor.
Thank you very much.